Good morning, everyone, and Happy New Year. This is Rebecca Strauss. I have my partner, Bob Schindler, with me this morning.
Good morning, everyone.
We are going to talk to you all this morning about the FFCRA and what happened in the legislation that President Trump signed at the end of last year, at the very end of last year, as it relates to the FFCRA. Spoiler alert, it's not very much. We're going to explain to you what it did, but frankly, it's pretty easy to explain. And so we expect this webinar to last probably closer to about a half hour, okay? We're going to probably in some of our upcoming webinars too aim to get you in and out a little faster. So we're looking at about 8:30 this morning. Today's topics, first of all, a disclaimer. We always like to have a disclaimer. What we're talking about today is current as of this morning at 6:30 a.m. when we finished the slides. As you know, in this COVID-19 world, things can change and change quickly. There may be, in this topic, for instance, there may be guidance from the Federal Department of Labor coming or from the IRS. There hasn't been yet, but we're looking for it. So whatever we're discussing today is current as of our knowledge as of 6:30 this morning. We're going to talk about how the new law extended, sort of, the FFCRA. Don't worry, we're going to explain that in detail, exactly what the new law did. We're going to explain how the new law impacts private entities, and we're also going to talk about how it impacts public entities, public employers. And frankly, that's really where Bob is going to step in, is with the public employers, because for the public employers on the webinar this morning, you know that the FFCRA was very different for you than it was for private entities, because you did not get the tax benefit, the tax credit. So the new FFCRA, let's talk about what it actually is. We're going to get into the nitty-gritty, and then we're going to summarize it for you, so do not be alarmed. If when we're in the nitty-gritty, your head is spinning, we're going to give you a nice, neat summary, too. It is included in this law. This is the actual law that passed. This is the first page of it, and it's the Consolidated Appropriations Act of 2021. And if you look down at the bottom, of the page, I just did a screenshot of my page when I pulled up the PDF of this to read it for you. So, and this bill is 5,593 pages long. So that is what Bob and I did over our Christmas vacation. I'm not sure what the rest of you were doing, but we had this 5,500-page new law to sort through. And how much of this impacts the FFCRA, you may ask? 5 pages. 5 pages of this law talk about the FFCRA. The FFCRA basically consists of 3 parts. This is the original FFCRA. It actually includes a little bit more than that, because there's parts that deal with the self-employed, et cetera. But for our purposes, there's 3 important parts of the FFCRA. The one is the Emergency Family and Medical Leave Expansion Act. That's Division C. There were no revisions to Division C. Okay, so the actual text of the Emergency Family Medical Leave Expansion Act, talking about who qualifies and what types of situations can present themselves whereby an employee would qualify. None of that has changed. FFCRA Division E creates the Emergency Paid Sick Leave Act. There were no changes to that division. Okay, same thing, no changes to who would qualify, et cetera. Both of those still contain the December 31st, 2020 expiration dates. But now, hold on to your seats, ladies and gentlemen, because it's Division G, FFCRA Division G, where the changes were made. And Division G is titled Tax Credits for Paid Sick and Paid Family and Medical Leave. This is where the changes happened. Okay, so the only revisions to the FFCRA happened in the section that discuss whether employers can take a tax credit for paid leave that they provide. And now let's talk about what exactly those changes are. The first bullet, there is no change to, but this is the actual language that gives some employers the ability to take a tax credit if they pay for leave that qualifies under the FFCRA. Okay? In the case of an employer, they shall be allowed as a credit against the tax imposed by Social Security and Medicare, right, of equal to 100% of the qualified sick leave, qualified family leave wages paid by such an employer. Okay, you with me? That's the exact language that gives your organization, some of your organizations, the ability to take a tax credit for the paid leave you pay. Next bullet, this language was amended. This section, the tax credit section, shall apply to wages paid with respect to the period beginning on, and it's when the FFCRA was enacted, and ending, it used to be on December 31st, now it's March 31st, 2021. Okay, that's a big change. So the section that allows you to take tax credits applies to wages paid through March 31st, 2021. More changes. What does the term qualified sick leave wages mean? It means wages and compensation. And again, don't worry, we're going to summarize this later, but here's the exact language, which are required to be paid by reason of EPSLA or EFMLA, or which would be required to be paid if the act had not expired on December 31st. If that's what that says. If the act expired on March 31st instead, and you would have been required to pay those paid sick leave, that paid sick leave or that emergency family medical leave, you can still take the tax credit. And here is your quick and dirty summary of what I just said. For any employee who would be entitled to that leave, if the act actually expired on March 31st instead of December 31st, and the employer pays the employee for that time off, the employer can take the same payroll tax credit that it would have if the FFCRA was still in effect. Another way of looking at this is beginning yesterday, there is no employee right to FFCRA leave. Okay? There is no right to FFCRA leave. If you do not provide an employee leave that would otherwise qualify for FFCRA starting in 2021, right, you have not violated the FFCRA. But if you choose to pay for time off that would qualify for the FFCRA, had the FFCRA not expired, you can take the tax credit just as you would have in 2020. I hope you are all with me. It's a little hard to do this by webinar instead of in person, because in person I would say, are you all with me? And you would all clap and cheer and raise your hand. Or do so. Hopefully that is what you are all doing early in the morning on this new year. You are clapping and saying, yes, I understand. Last bullet point is important. If you choose to pay employees for this time that would otherwise qualify for the FFCRA, had the FFCRA not expired, and you want to take the tax credit, continue to use the same leave request forms that you were using before. Okay, and we've got those on our resource center, and if you need them, please let Bob or me know. I'm guessing by this point in the game, if you are subject to the FFCRA, you have the forms in place, because you will still need to prove to the IRS that that employee qualified for FFCRA. And the questions on the request forms is your documentation of whether an employee qualified for that leave or not. So that is the law. That is all that was done in those 5 pages of that 5,500 page law. it said the FFCRA is still expired, but you can choose to grant the leave to employees who otherwise would have qualified, and if you do, you can take the tax credit. So that's pretty simple, right? You may have to say it 2 or 3 times to get your head around it, but once you do, you'll find that it's not very complicated, but of course it has generated lots of questions that came in, frankly, to us, just an individual counseling questions, but also prior to this webinar. So we are going to get started straight into the questions. The first set of questions deals with public employers, either local governments or public schools. Bob is one of our lawyers in our new Detroit office. Bob deals almost exclusively with public employers, so he is the guy to answer these questions. So Bob, why don't you take it away the next few slides?
Sure, absolutely. Thank you. Yeah, and we've got a few questions in already on the Q&A, and some of them are kind of overlap a little bit here, and so we'll try and make sure we get through all of it as we go through this here. So, one, are state and federally funded organizations eligible for the tax credit when they do not pay into Social Security? I'm going to kind of maybe pull these together. Will local government employers be eligible to offset their payroll tax from 1/1 through March 31st as they did previously, and to what extent do these changes impact K-12 public schools? So a couple of points on this one, which is as far as governmental entities go, you didn't receive the tax credit before, and you don't receive the tax credit now. So you thankfully don't have the mandate, but also still don't have the tax credit. You know, as far as the wages and not paying FICA on those wages as previously, that's also still in effect. So you still get that benefit of the fact that these wages, these sick wages are not wages for Social Security purposes, and therefore you save the 6.2% on the FICA on those wages, but you don't get the full payroll tax credit that private employers do. So as far as to what extent this impacts K-12, that's it. I mean, that's going to be the biggest point, is it takes away the mandate that you provide it without the benefit of the tax credit, but still continues that same FICA benefit you had before. So next, if my organization is not eligible for any payroll tax credit, A, must we continue paying FFCRA like paid leave? Can we continue to pay FFCRA like paid leave? Should we continue to pay FFCRA like paid leave? And are public employers extending COVID leave benefits voluntarily? All right, so again, must we continue? No. Can we continue? Yes. Should. So this one gets a little trickier, right? And I think this is always a matter of those where you have to sort of look at your organization and your situation and go from there. You know, this goes in, you know, one of the questions we have in the chat right now as well asks, you know, can an employer choose to pay either the Emergency Family and Medical Leave Expansion Act or the Emergency Paid Sick Leave Act, or does the employer have to choose to pay both or neither? And Rebecca, you can correct me if you think I'm wrong here, but my view on this one is you don't have to do both or neither, right? Now, what I would say is be consistent in that process, right? So in other words, I know from my public school employers, and I had this conversation with a couple of clients yesterday, you know, their position was, well, look, if it's an EPSLA leave because somebody has been exposed or test positive, we're not going to want them in the school anyhow. But what's really killing us is the extended FMLA leave. And so can we give the benefit on the 2 weeks, but not for the 12? And as I see it, yes, you can make that choice. Now, where as an employer, right, where things can get problematic is if you're picking and choosing when to give one and when not to give the other. So I would make a blanket process of it, a decision on it, and kind of move forward that way. And then the last one, are public employers extending COVID leave benefits voluntarily? It's still young in this process for me to have a pulse on what people are or are not doing. After all this, yesterday was the first day back for everybody mostly. And so I'm still figuring out where the pulse is on that, but I think that's probably going to be where many land is kind of the process that we just talked about.
We can just do the rest of these together, because I think the rest of these questions really
both,
apply to public and private. Because you asked me to disagree with you, you're one of your last answers. I will say I do not disagree with you. That's a question that came in several times just from the live Q&A, and we just got last night as well ahead of the webinar. But after we prepared these slides, is the way I phrase it is, can employers kind of pick and choose, right, which types of FFCRA leave to offer now? I think they can. The only caveat I would add is it would not surprise me if the Department of Labor or the IRS came out with some guidance on that, because that is such a big question around the country right now. So stay tuned. But my reading of the new law is that yes, you can choose to provide some types of leave that would have been required under the FFCRA, but not provide others. Okay, now back to the slides. Question number 5, are there any differences between the FFCRA prior to December 31st and beginning January 1st? I think we already answered that, but just to reiterate it in case it's still unclear for some of our listeners, prior to December 31st, FFCRA leave was mandatory. It is now not mandatory. But the tax credit situation, if you do offer and pay sick leave in part or in whole, the tax credit situation has not changed. Okay, you can still take those tax credits, but you no longer are required to provide the leave. Number 6, are we allowed to roll over the 80 hours and remaining hours if an employee has not used it? Let me just expand that question a tad. So the FFCRA for emergency paid sick leave provides 80 hours of emergency paid sick leave. That 80-hour bank has not changed. It has not been expanded. Remember, you can take the tax credit if the FFCRA had an expiration date of March 31st instead of December 31st. So the 80 hours continues. If an employee already used up the 80 hours, they're out. Doesn't replenish at the beginning of the year. If they had not already used up the 80 hours, they can use whatever remains of those 80 hours up through March 31st, and you can take the tax credit for it if you offer that to them. If we elect to continue offering emergency sick time, do we need to replenish the banks or just carry over? Same answer, right? That's the general way to think about it. Just in your minds, strike out the December 31st expiration date for the emergency paid sick leave when you're trying to figure out if someone would qualify for it. Just strike out the December 31st and insert March 31st, and then think about whether they would qualify for that leave. If they do, and if you choose to pay for it, you can take the tax credit. How does the EFMLA coordinate with traditional FMLA this time? Can an employer designate its own leave plan and still get tax credits? Let's answer the first part of that question first. This time around, if you pay for leave that otherwise would have qualified for EFMLA, had the EFMLA not expired, the employee is not actually getting EFMLA, right? The EFMLA actually did expire. We're just pretending, right? If it did not, would the employee get it? And if so, you can take the tax credit. But it did, in fact, expire. So if an employee is taking reasons that are covered only by the EFMLA, that would not otherwise be covered by the FMLA, which is probably all the reasons they would qualify for the EFMLA, that would not count as FMLA time, because that would not be an FMLA qualifying event, right? If an employee had to stay home because a child's school was closed because of COVID-19, that's an EFMLA reason, but not an FMLA reason. Therefore, it would not, that time, whether you pay for it or not, does not count against their FMLA bank. Can an employer design its own plan and still get tax credits? You can get the tax credits if the leave that you are providing would have been required by the FFCRA if the FFCRA had not expired. Then you can still get the tax credits. But if it's your own leave that was already there, you can't just go ahead and get the tax credits. Remember, the FFCRA leave was in addition to any leave plan you already had. So, but if it's an additional COVID leave plan that provides leave that would have been required, then you can get the credits. Bob, any disagreements or additions to my monologue there?
No, none, Rebecca. Thank you.
People know I do love to talk. You get me started. It's hard to stop. Number 9, if an employee is non-compliant outside of the workforce with mask wearing, et cetera, and they get COVID, let's just assume for the point of this question, that's the reason they get COVID, are they exempt from the FFCRA leave? First of all, FFCRA is not required now anyway, so I'm not sure if this question is as important as it was before December 31st, but even before December 31st, the person still gets, qualifies for FFCRA. There is no exemption in the FFCRA for stupid behavior.
Well said. Right. That's what I was going to say as well. Yes.
I feel kind of like I'm talking to my teenagers right now. When I
we can't police everything they do, unfortunately, and probably fortunately as well. So
maybe I'll just make up a sign for my home: no exemption for stupid behavior. Applies to our kids and to our employees. Is the FFCRA going to be extended? I assume that question, for the purpose of this webinar, I'm going to assume that question means after March 31st, right? So we have a kind of sort of weird extension going on right now. Is anything going to happen after that? I have no idea. And usually once I say that, I say, but if I had a crystal ball, and I will tell you what I think based on what I'm hearing, just my best guess. But to be blunt, this is election day in Georgia. The balance of the Senate hangs in the balance. If the Senate, if Georgia elects to Democrats for senators, and then it's split in Georgia, and then Kamala Harris becomes the tiebreaker, which means that the Democrats will essentially have control of the House, the Senate, and the White House. It would not surprise me if there was a further extension in some fashion.
Yeah,
if that does not happen, it's unlikely.
Right.
Go ahead.
If that happens, Rebecca, I mean, with that political swing, there's always even the potential that Congress goes back and looks at the potential of mandatory or other things. But that's so hard to tell at this point right now, to your point.
Yep, it is really anyone's best guess right now. So I am not putting my thumb on either side of that. Even if I were a betting person, I would not be betting on that today. Talk to me in the next few weeks, and maybe I'll feel more confident in giving my opinion on that. All right, last question that came in prior to the webinar. What do we do if an employee receives the vaccine and then has side effects, symptoms of COVID? So this is not directly related to this quasi-extension of the FFCRA, but it is sort of. We did not answer questions that were not related to the topic at all, but this one kind of sort of is. So let's talk about it. The first thing I'm going to say is symptoms that are caused by the vaccine are not addressed in any law, regulation, guidance. anything, right? About how that impacts qualifying for the FFCRA, how that impacts whether you have to stay home under Public Act 238, et cetera. My advice is to call your lawyer and talk about it individually on a case-by-case basis, because this is really a risk analysis question. I think there's certainly an argument that that person would qualify for FFCRA, right? And therefore you could give them paid leave for that time, and therefore you could take the tax credit. I think the argument is there, but that's what it is. It's an argument. It's not written out in black and white anywhere. We have 2 minutes left. The last slide is a poll that I think you're going to want to take because it addresses the very last question, and it was a common question. But before we take the poll, Amy, I know you're ready to run the poll, so just hold on for just a second. Bob, why don't we look at some of the live questions that have come in?
Yes.
Just for a few minutes here and see if there's any we haven't already answered that we can help people with.
Yeah, so I'm looking through now as well. There are a few who have asked about, okay, if they had 12 weeks in 2020, does that start over again in 2021 or some variation of that? And again, thinking through this on the fly, my thought on that one is that under the act, as far as the tax credit goes, it is if it would have been required prior to December 31, right? So if they've already received 12 weeks and they wouldn't be obviously in another full, I guess, depending on how your FMLA works, as you said, Rebecca, this isn't actually FMLA leave, but it wouldn't have been required either, unless maybe your policy you run on a calendar year basis, I suppose, and then you could take another 12 and still get the tax credit for it. That's kind of my read on it. Any thoughts on that?
No, I don't have anything to add on that other than perhaps we'll get some additional guidance.
Yeah,
right.
But otherwise, if let's just say, for example, I know in working with schools, most work on a rolling calendar method for FMLA. Obviously, again, there is no requirement here to provide another 12 weeks if somebody already had 12. But I think if you're on a rolling calendar, there also probably you wouldn't be able to get another tax credit for another 12 weeks. If you've already given 12 and they wouldn't qualify otherwise under the requirements from beforehand.
So we've gotten, Bob, a number of questions. I'm just going to lump them all together regarding the 80 hours in 2020, right? If they haven't used them all or if they have, what happens in 2021? For instance, one question, if we do not extend the sick leave and folks have leftover 80 hours, can they still use them this year? The answer is no, because the emergency paid sick leave, that 80 hours, did expire December 31st, right? So that leave program is over. If you choose to extend benefits to pay for leave that would have qualified had it not expired, then you can take the tax credit, but you're under no obligation to do so. And there's not an additional number of hours over those original 80. Okay, any other questions that you think are that we should get to before we get to the poll?
One I just want to address real quickly. Someone had asked, the question says, you consider a medical exemption for not wearing a mask stupid behavior? No, of course, that is not what Rebecca or I were saying. Obviously,
we were answering.
Otherwise, I don't see any other one right off the top of my head right now that we haven't addressed so far. I think we should get to the poll. And
I think a lot of them we answered in some fashion live. If you have any additional questions, please reach out to Bob or I or any of your favorite Miller Johnson lawyers. Okay, here is the question, the most common question. And frankly, we didn't know how to answer it. So we thought we would ask a poll. Bob asked the question earlier regarding public schools, but this is, I want to know for everyone. I wrote this, it's my fault. I said companies, but I really should have said organizations. I don't care if it's a company or not. What do you think your organization is going to be doing now that providing these paid leave benefits is optional? Do you think your company will continue? Do you think your company will end these additional paid benefits, or is your company, have they not made a decision yet? Has your organization not decided yet? Okay, that is perhaps some of the most helpful information during this entire webinar, Bob. Employers want to know what everyone else is doing, right? That's important in every organization's decision-making process. What are our competitors doing? So now you know of the organizations that have made a decision, 47% are continuing to offer the benefits that were offered under the FFCRA. Does that surprise you, Bob?
It does. Yeah, that is that high, and that the ending is so low. It surprises me a little bit. How about you?
You know, I'm surprised that the numbers, the disparity is so great, but the result does not surprise me. And here's why: most employers want employees to stay home if they're symptomatic or under quarantine or what have you, because if those employees come to work, some coworkers won't care, but some coworkers will. And it will be extraordinarily unpleasant situation for the HR folks, right, who are mostly on the call, right, when the coworkers come and say, you know, Bob's hacking up a lung over here, right? And when people are paid for their time off, they're much more likely to stay home.
Yeah.
They're much more likely to report symptoms honestly. They're much more likely to be willing to get tested and report a positive test honestly. We all know we've got people who aren't reporting honestly, right, because they want to come to work, because they need the money. So it doesn't surprise me that most employers are going to continue to do that. I expect this may shift throughout the next 3 months. Remember, if you decide to do it now, and a month from now it's not, for whatever reason, working out the way you thought it would, you can always stop then because it's not mandatory, right? So maybe some of that will happen.
Yeah, no, that's it's a great point. I agree with you that if you're not incentivizing people to stay home, they won't, and that can obviously be a danger to the workplace. I think dealing in public schools, maybe it surprised me because so much of what I've dealt with over the last several months has been the the emergency FMLA leave, and then the essentially the inability to have in-person school in many places because you can't staff for in-person school. And I know that's been a nightmare for a lot of my clients. So maybe that's part of what surprised me about it. And it's my own mindset here in working with my client base.
We had an interesting question: how many employers are actually on the call this morning, and how many took the poll? I don't know how many took the poll, but there were about 350 individuals on the call this morning. We got another comment about referring to people who don't wear masks as stupid, and to the extent that that was insensitive and maybe stupid for me to say, I apologize for my own stupidity in referring to it that way. Sometimes in my efforts to throw a little humor into something, sometimes I can be insensitive and take it too far. So I do apologize. That was not the intent of my joking around. The gist of the question we were answering was, if a person does not follow CDC guidelines, and that is the reason they contract COVID, does an employer still have to provide paid COVID leave benefits? That was the question. And so that was the question we were answering. The question did not imply that the reason the person was not wearing a mask was because they had a medical exemption or otherwise would not have been asked by the CDC to wear a mask in the first place.
Right. And I can tell you too, on that same point, Rebecca, I mean, right, we get questions all the time that are focused on people engaging in behaviors that are advised against. And if they get COVID, do we still have to do so? And that's what you were addressing.
Right. Right. So, but again, I do apologize if that offended anyone or rubbed people the wrong way. That was certainly not our intent. And as one client has up all over their facilities, they have signs all over that say, assume positive intent. I think that works for lots of organizations and lots of relationships, and hopefully this one. So that is all we have for you. Again, if you have any other follow-up questions or comments, please feel free to follow up with Bob or me or any Miller Johnson lawyer. Thank you so much for coming this morning. Again, Happy New Year. We hope 2021 is better than 2020 for all of us. We hope you all stay healthy and well, and we'll talk to you again soon.